All right, everyone, welcome back. And I want to go over first some of the facts that we went through yesterday in part one of the Jussie Smollett case. So first is a special grand jury began on August 23rd, 2019, when Judge Tooman appointed Mr. Webb as special prosecutor. That's fact number one that I thought was important. Fact number two, the Office of Special Prosecutor ultimately requested on February 11th, 2020, that the special grand jury indict Mr. Smollett, and the grand jury returned a true bill. So they said yes. OSP then filed a 6-count indictment, so they indicted him, Jussie Smollett, charging Mr. Smollett with making 4 separate false reports to CPD officers related to his false claims that he was the victim of a hate crime, knowing that he was not the victim of a hate crime. And lastly, I thought it was important to point out all of the work that the special prosecutor put into this. So they did 53 interviews, issuing more than 50 subpoenas and or document requests, and collecting more than 120,000 pages of documents, or more than 26,000 documents, as well as text messages, data, and auto recordings. All right, so let's move on to where we left off yesterday and pick up from there. So we're starting here in section 2, discussion of the OSP's 5 final conclusions and supporting findings related to the conduct of the CCSAO in the initial Smollett case. So basically what Kim Fox, the prosecutor for Cook County, Illinois, what they did during their initial investigation. After the CCSAO dismissed the initial Smollett case on terms that many believe were very favorable to Mr. Smollett, there was speculation in the media regarding whether something illegal or improper had gone on behind the scenes at the CCSAO to allow Mr. Smollett to achieve the particular resolution he received. Among other things, there was public speculation that Cook County's attorney, Kimberly M. Fox, may have been influenced in an improper manner by prominent people who reached out to her to discuss the initial Smollett case. Thus, as part of its investigation, the OSP thoroughly investigated and evaluated whether State's Attorney Fox or anyone working at the CCSAO committed any crime relating to the prosecution or resolution of the initial Smollett case. As a result of the investigation, the OSP has concluded that it did not develop evidence that would support any criminal charges against State's Attorney Kim Fox or any individual working at the CCSAO. However, as a result of the investigation, the OSP did develop evidence that establishes a substantial abuses of discretion and operational failures to the CCSAO in prosecuting and resolving the initial Smollett case. Okay. The OSP has reached 5 major final conclusions relating to the conduct of the CCSAO. Below is a summary of those conclusions and supporting findings, but without a discussion of the actual evidence that supports each of these conclusions and findings. The evidence supporting each is detailed in the OSP's 60-page summary report as discussed above. And as we know from yesterday, they're not releasing that because it's of evidentiary value. And there's evidence in there from the research that they did, all of the documents that they collected. There's evidence in there, and it's not included in this. However, the special prosecutor wants that released because he feels it should be for the public to see, for public consumption. All right, so conclusion number 1. The OSP did develop evidence that establishes substantial abuses of discretion and operational failures by the CCSAO in prosecuting and resolving the initial Smollett case. The OSP developed evidence that establishes 3 substantial abuses of discretion and failures by the CCSAO in prosecuting and resolving the initial Smollett case. First finding of abuse of discretion. The CCSAO's process and decision-making for resolving the initial Smollett case were a substantial abuse of discretion and represented a major failure of the operations of the CCSAO, including in the following ways. On March 26, 2019, 19 days after filing the indictment against Mr. Smollett, the CCSAO dismissed the entire indictment against Mr. Smollett on the following terms. 1, complete dismissal of the 16-count felony, this was a felony, indictment against Mr. Smollett. 2, no requirement that Mr. Smollett pleaded guilty to any criminal offense under Illinois law. 3, no requirement that Mr. Smollett admit any guilt of his wrongdoing. In fact, following the court proceedings on March 26, 2019, Mr. Smollett publicly stated he was completely innocent. 4, the only punishment for Mr. Smollett was to perform 15 hours of community service that had no relationship to the charge conducted. 5, only requiring Mr. Smollett to forfeit his $10,000 bond as restitution to the city of Chicago, in parentheses, a figure amounting to less than 10% of the $130,106.15 and police overtime pay that the city alleges it paid solely due to Mr. Smollett's false statement to police. And 6, no requirement that Mr. Smollett participate in the CCSAO's Deferred Prosecution Program, Branch 9 DPP, which would have required a 1-year period of court oversight over Mr. Smollett. Almost across the board, lawyers who currently work in or previously worked in the CCSAO's criminal division who were interviewed by the OSP, including State's Attorney Fox, were surprised or shocked by at least some fact of the dismissal terms. So, there were people that just probably just mouths were gapped open like, oh my God. Okay, the CCSAO decision makers of the initial Smollett case, acting state's attorney Joseph Magatz and lead prosecutor Lisa Lanier, did not learn of any new evidence between the CCSAO filed a 16-count indictment against Mr. Smollett on March 7, 2019, when the CCSAO believed it had a strong case against Mr. Smollett, and March 26, 2019, when the entire indictment was dismissed as described above. Didn't take much time for them to dismiss. The CCSAO decision makers on the initial Smollett case have significantly and meaningfully divergent explanations for how the resolution was reached, including who negotiated the terms, whether Mr. Smollett was offered the opportunity to participate in the DPP, and whether the terms of the resolution were molded after the requirements of the DPP. The terms of Mr. Smollett's resolution do not track the requirements of the DPP. The CCSAO did not screen Mr. Smollett's case to determine if it was eligible for referral to the DPP. So it wasn't even screened, it wasn't even considered. The CCSAO did not rely upon any specific similar CCSAO cases when resolving the initial Smollett case. Okay, the CCSAO's decision to advance the initial Smollett case from April 17, 2019 to March 26, 2019 to dismiss it minutes before conducting the dismissal hearing did not provide notice to the media or public, despite knowing there was significant interest in the case, including that the media had filed a petition to have cameras in the courtroom. And they were, I don't know if they were denied that. Well, it's saying that they filed petitions. So, okay, it's not about them denying, it's that they weren't even made aware of it. No one was until it happened. Okay. Ms. Lanier read a statement during the dismissal hearing that she drafted in conjunction with Mr. Smollett's counsel, which was atypical. And I'm reading this for the first time right along with you. So if some things seem obvious and repetitive, just know that I'm reading it and then I'm, so. All right. Next, the CCSAO did not consult with the CPD about the terms of the resolution and intentionally. Now that's a very accusatory term that they're using, but they're saying and intentionally chose not to alert the CPD that the case would be dismissed until minutes before the hearing. Despite all the diligent hard work the CPD, the Chicago Police Department, put into investigating the case, and the fact that many CCSAO interviewees would have considered the CPD a victim of Mr. Smollett's alleged crimes and or for purposes of restitution. Okay. Second finding of abuse of discretion. I think we can, let's stop there. Let's stop there and we'll pick up part 3 tomorrow. So yeah, it's interesting. It's starting to show what, Kim Foxx and Kim Foxx's office did not do, like letting the police department know they were dropping the case just moments before they announced it, and not letting the media into the courtroom because the media didn't know about it. I mean, everyone knows this was a very high profile case, and it looks to me as though a lot of this was done deliberately. And I think that based on what we're reading so far, that's what they're telling us. So they intentionally did these things. All right, so we're going to leave off there. Thanks for stopping by the Daily Facts, and we'll have part 3 out tomorrow at the same time. Take care, and don't forget to like, share, subscribe, and leave a comment. All right, this is the Daily Facts. Talk to you soon. Bye.